Happy Valentine's Day! Welcome to this month's issue of Legal News that you can use. I'm Christina Ciceron, a partner at Ciceron Law, Community Association Counsel, and the purpose of this month's video is to talk to you about what should and should not be discussed in executive session. In this season of Sweets and Sweethearts, I thought we should address a topic that both community managers and board members love to call our office about, and that's executive session. This is a first of a two-part series on executive sessions. This month, we're discussing the 5 items that can properly be addressed under the Civil Code in executive session, and next month, we're going to talk about the right way to prepare your executive session agendas, meeting minutes, and some other fun topics related to executive session. So let's get started. Legal matters are properly discussed only in executive session. It's important to remember that your legal counsel does not need to be present for you to discuss a legal matter in executive session. Further, the legal matters in executive session are importantly kept there because you want to protect your attorney-client privilege. Both pending litigation and matters that are actually in litigation are properly discussed in executive session. It's also important to keep those legal matters in executive session because you want to preserve confidentiality with potential settlement offers and in your litigation strategies that you might be discussing with your legal counsel and your fellow board members. Item number 2, formation of contracts. This is a 2-part process. Contracts should be held only in executive session. You meet with your potential bidders, you review their proposals and bids in executive session, and then once the board has made a decision, you ratify the decision in open session and actually approve the contract formally with a motion made in open session in front of the membership. The purpose of dividing out contracts into a 2-part process is to prevent unfair bidding practices by third-party vendors and prevent them knowing about the information in the other's proposal. Item number 3, properly held in executive session, disciplinary hearings. I want to note that members do have the right for a CC&R or a rule violation to request the board to hear their matter in open session. I always prefer these to be done in executive, and I advise my clients of that where possible. Members can come to executive session if they are called to a disciplinary hearing, but they are only allowed to attend the part of executive session where their potential violation is being discussed by the board. Item number 4, personnel and employment matters. This includes hiring, firing, raises, and anything related to your staff at your association. Please note that if your association doesn't have employees, that doesn't mean that there will not be some items that are properly discussed under the personnel exception for executive session. For example, if you wanted to give your community manager a raise or a bonus or discuss potential issues related to your community manager, do it in executive session. Last but not least, items related to delinquent assessments. Both payment plans for delinquent homeowners as well as foreclosures are properly discussed in executive session. In fact, the board cannot delegate to a third party like their community manager or a collection vendor the decision regarding foreclosing on a delinquent homeowner. That should only be done in executive session by a vote of a quorum of the board of directors. Next month, we're going to continue with our discussion on executive sessions and talk about agendas and how to take executive session minutes and who can properly attend executive session meetings. Remember to like our Facebook page, leave us some feedback down below, and don't forget to give us a call if you've got a question regarding one of your associations and what can and cannot be discussed in executive session. We love to hear from you. Look forward to talking with you next month about this item a little bit more. Until next time. One of our clients is in the process of restating their bylaws to get rid of cumulative voting. And since the concept of cumulative voting is something that I consider very scary, I thought I would take the opportunity this month to help you understand exactly what cumulative voting is and why you should get it removed from your governing documents if it exists in your community.